There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Probation will be a waste of time in this matter, so I will revoke and remand you to serve your sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
All right, guys. Today's courtroom drama features yet another sovereign citizen disaster, but this time it's a twist. This woman's in court for violating probation after a failed drug test, and instead of doing the smart thing and getting a public defender, she pulls the classic sovereign citizen move and tries to defend herself. Honestly, though, I don't think she even buys her own argument. She's probably just parroting a script she found online, hoping to dodge consequences. What do you guys think? She a true believer or just desperate? Drop your thoughts below, and if you're enjoying content like this, hit that like and subscribe. Let's dive in.
Your Honor, this comes before the court today on a probation violation hearing. And it's the intent of the defendant at this time to stipulate. And I do believe there's a agreed sentence, as you would say in this case.
All right. Ms. Clark, you've heard the announcement of your attorney. Is that what you want to do? Admit to the violations?
No, actually, I'm going to make a motion for my attorney to withdraw. I got this myself.
Oh, okay. What's the reason for that?
I just want to represent myself.
Okay. All right. Well, somebody give her a waiver of attorney form. Okay. It's muted for some reason. All right. Well, I've already gone over these rights with you, so you should understand them, but you have the right to hire your own attorney. If you can't afford to hire an attorney, I've already appointed one. You qualified. You do have the right to represent yourself as well. And that's what you want to do today?
Yes, sir.
All right. If you want to waive your right to an attorney, when we do this, you have to follow the rules of procedure and evidence, just as if you're an attorney. You understand that?
Yes, sir.
All right. Has anyone promised you anything or threatened with anything to get you to waive your right to an attorney?
No, sir.
All right. Looks like you've already signed it and sent it in here. Did you understand this form you signed?
Yes, sir.
I'll accept your waiver and allow you to represent yourself. All right. Are you wanting to stipulate to the violations, or do you want to contest the hearing?
I'm going to contest it.
All right. Mr. Hollis here.
Yes, Judge, I can grab him real quick.
Okay. Okay, state has the burden. Any opening statement, Mr. Marcinski?
No, sir. Thank you.
All right, Ms. Clark, any opening statement?
No.
Well, there goes any chance she had of saving herself. I'm honestly shocked she hasn't busted out the full sovereign citizen script yet, you know? The I don't consent and this court has no jurisdiction nonsense. Thankfully, we've been spared that headache so far, but skipping or botching your opening statement when you're defending yourself. That's courtroom suicide. It's literally your one shot to sound sane and show the judge you're serious. Blowing it like that, might as well hold up a sign that says, I'm lost. What do you guys think so far? Is she clueless or just panicking? Let's dive back.
All right. State may call this first witness.
Thank you, sir. The state would call Court Service Officer Christopher Hollis. Sir, will you please state your name for the record?
Chris Hollis. I'm a court services officer.
In that job occupation, were you assigned the supervision of a Miss Ashley Clark? That supervision being for an endangering a child underlying 12-month sentence?
That is correct.
On May 18th of this year, 2023, did you test Miss Clark for the presence of drugs?
Yes.
And what was the result of that UA sample from Miss Clark?
It was positive for methamphetamine.
So her
Stating that
UA was positive for methamphetamines, and she also, in response to that positive UA test, signed in a statement of admission of using methamphetamines.
That's correct.
Did you order her to report on June 2nd, 2023?
I did.
And did she appear on that day?
She did not.
Has she appeared or reported to you since that time?
No.
Sometime after May 24th of 2023, were you advised by local authorities of her being arrested for a new crime?
Yes, and I did. I received that, and apparently she has new charges.
To your knowledge or to the notes, did Ms. Clark ever report that negative law enforcement contact with your office?
No, she did not.
That will be my questions for Mr. Hollis at this time, Your Honor. Thank you.
All right, Ms. Clark, do you have any questions for Mr. Hollis?
No,
All right, do you have any further evidence or witnesses, Mr. Marcinski?
Not at this time, Your Honor. I do not.
All right, Ms. Clark, you have time to, now it's your turn to present any evidence if you want to. Do you wish to present any evidence?
right now I see no evidence. This has the needed personal subject matter jurisdiction.
If you want to present any evidence, do you want to present any evidence?
Honestly, it's hard not to feel at least a little bad watching her self-destruct like this. Yeah, she's in court for a reason, but seeing someone embarrass themselves that badly, especially in public, is rough. At the same time, like you said, she had help right there. A free attorney literally sitting beside her, ready to step in, and she just waved him off. That's the part that kills me. Sovereign citizen logic makes no sense. It's like choosing failure on purpose. Do you feel bad for her or think she deserves every bit of it? Let's jump back in. Things are about to get brutal.
No? Okay. Well then, closing argument, Mr. Marcinski?
Your Honor, at this time, the state believes it is shown by a preponderance of the evidence that Ms. Clark is in violation of her probation and conditions of probation imposed by the court therein. The state's going to ask that you find that she is in violation of that probation. The state would point out that this is a misdemeanor probation for endangering a child. Therefore, Ms. Clark is entitled to no graduated sanctions, intermediate sanctions, or other relief set forth by the legislature on felony probations. Due to the litany of violations, the continued drug use, the failure to follow through with her treatment requirements, the state believes that she's shown that she's not amenable to probation and would recommend the court revoke and remand her to serve her underlying sentence.
All right, Ms. Clark, closing argument?
There are no facts to dispute before this court. I see no evidence that has the needed personal subject matter jurisdiction. The state is a fictitious plaintiff. The state of isn't here to testify. No injured man or woman is present before this court to provide firsthand knowledge. I am acting as surety for the named principal to contest jurisdiction. I am aware this is a taxable event and an excise tax is owed, and I want to be in compliance with the IRS code.
Okay. It'll be the order and judgment of this court. Well, first of all, I'll make my findings. The state's shown by preponderance of the evidence that you violated probation in this case using methamphetamine around the 18th, as evidenced by the 18th of May this year, as evidenced by the positive UA and the admission. Also find that you failed to report in violation of probation as alleged. That would be the June 2nd, 2023 date. You failed to successfully complete outpatient treatment at Summer Mental Health as ordered by the court, so I find you violated probation there as well. You also failed to report law enforcement contact within the business day in violation of the orders of probation. You have violated, it does in a very substantial way. I will go ahead. It appears as if probation will be a waste of time in this matter, so I will revoke and remand you to serve her sentence, take her into custody.
All right. $1,200 every minute I'm in jail.
Can you believe this? She's actually demanding $1,200 for every minute she spends in jail. After violating her probation, putting her child in danger, and continuing her issues, With substance abuse, she's now claiming she should be paid for being in custody. It's hard to understand that kind of thinking. Honestly, I no longer feel any sympathy for her situation. When someone repeatedly breaks the rules and endangers others, facing time in jail seems like a fair outcome. On top of that, she made an inappropriate comment to the judge before her arrest. A level of disrespect that really shouldn't be overlooked. Some people who follow sovereign citizen beliefs think that rejecting the court's authority somehow means they're above the law or owed compensation for being held accountable. But that's just not how the legal system works. She violated her probation and now has to face the legal consequences. There's no payday waiting for that. Now that you've seen this situation play out, what's your opinion? Do you think she has any realistic chance of avoiding her sentence? And do you believe she actually received that $1,200 per minute she's asking for? Share your thoughts in the comments. And if you enjoy following courtroom cases like this, feel free to like and subscribe for more updates. Thanks for watching.